Thank you, Speaker. I rise to speak in support of the Crimes Legislation Amendment, Organised and Gang-Related Crime Reforms Bill 2026. And can I just say at the outset, Speaker, that there are many areas of this bill that I could speak to, but I would like to probably just hone in particularly on the bail laws aspect of the bill. In our state, bail laws play a crucial role in mitigating risk and protecting the community after a person has been charged with a criminal offence. This government has a strong track record of bail reform to improve community safety and public confidence. That includes reforms requiring people charged with serious domestic violence offences to show cause why they should not be detained until their case is determined, ensuring that all bail decisions in New South Wales are made by judges, and introducing a temporary strict bail test for young people charged with certain repeat offences. We are committed to making sure that courts and police have the tools they need to properly assess risk and keep the community safe when bail decisions are being made. This bill builds on that important work in the context of serious and organised crime, which remains a major concern for our community. In particular, the bill amends the Bail Act 2013 to ensure that an accused person's alleged involvement in and links to organised crime are appropriately considered in bail decisions. It also expands the offences for which the granting of bail can be temporarily stayed while an urgent detention application is filed. These are offences that have given rise to significant community concern in the context of organised crime. Section 19 of the Bail Act provides that a bail decision maker must refuse bail if satisfied that there is an unacceptable risk that the accused person, if released from custody, will fail to appear at proceedings, commit a serious offence, endanger the safety of victims, individuals or the community, or interfere with witnesses or evidence. The assessment of those potential outcomes or bail concerns involves consideration of the matters set out in Section 18(1) of the Bail Act. At present, that list includes whether the accused has a history of compliance or non-compliance with certain conduct restricting orders, including apprehended violence orders, non-association and place restriction orders, and supervision orders. This bill will amend Section 18(1)(f) of the Bail Act to require a court to consider any history of compliance or non-compliance with serious crime prevention orders, or SCPOs, and firearm prohibition orders, or FPOs, as part of the court's assessment of bail concerns. FPOs are administrative orders made by the Commissioner of Police against a person considered not fit in the public interest to possess a firearm, fail to appear at any proceedings for the offence, commit a serious offence, endanger the safety of victims, individuals or the community, or interfere with witnesses or evidence. Serious crime prevention orders are judicial orders made by the Supreme Court or the District Court after a hearing on the application of the Director of Public Prosecutions, the Commissioner of Police, or the New South Wales Crime Commission, where the relevant grounds are met. Before making an SCPO, a court must be satisfied that the person has been convicted of a serious criminal offence or involved in a serious crime-related activity, and that there are reasonable grounds to believe the order would protect the public by preventing, restricting or disrupting that person's involvement in serious crime-related activities. Both SCPOs and FPOs can be made in respect of participants in organised criminal activity. Adding SCPOs and FPOs to the list will ensure that compliance or non-compliance with these important conduct restricting orders must be considered by a court when assessing unacceptable risk. Section 18(1)G of the Bail Act also requires the court to consider whether an accused person has any criminal associations. The bill will amend Section 18(1)G to put beyond doubt that this includes criminal associations with persons involved in organised crime. That is consistent with the existing case law in Miriam versus Director of Public Prosecutions. The bill also ensures that bail decision makers consider whether the offence or offences a person is charged with are alleged to have been committed in the context of organised crime. Section 18(2) of the bill sets out matters that may be relevant to the court's consideration of the seriousness of the offence for the purposes of the unacceptable risk test. At present, this includes whether the offence is of a sexual or violent nature, whether it involves possession or use of an offensive weapon, the likely effect of the offence on the victim and the community, and the number of offences likely to be committed for which the person has been released on bail or parole. The bill will amend Section 18(2) to explicitly include whether the conduct the subject of the charge is alleged to have occurred in the same course of organised criminal activity. That amendment makes clear that an allegation that offending occurred in the course of an organised criminal activity is relevant to the court's assessment of whether the offence is a serious offence and to the seriousness of that offence itself. In addition to those changes relating to the consideration of unacceptable risk, the bill will allow a decision to grant bail for more serious offences to be stayed if our most senior prosecutors intend to return to the court to contend that the accused person should be remanded in custody. Section 40 of the Bail Act allows the court's decision to grant bail for a serious offence to be stayed for up to 3 days if an urgent detention application is to be filed in the Supreme Court, subject to the written approval of the DPP or the Commissioner of Police or a member of the New South Wales Police Force authorised by the Commissioner to exercise that function. In those circumstances, the bail decision is stayed and the accused remains in custody until the Supreme Court hears the detention application and makes a bail decision or refuses to hear the detention application. A relevant court is notified that the Crown does not intend to proceed with the detention application or 4 p.m. on the third business day after the bail decision was made, whichever occurs first. Currently, the serious offences to which Section 40 applies are murder and other offences punishable by imprisonment for life, sexual assault and serious domestic violence offences. The scope of offences to which Section 40 applies is deliberately narrow, confined only to a limited class of high-risk offences. That is because the provision has a significant impact on the liberty of an unconvicted person after a court has granted bail. The bill will amend Section 40 to ensure that certain serious firearms and kidnapping offences that have heightened community concern in the context of organised crime are subject to the stay of release requirements. The bill adds 4 charges to the scope of Section 40 of the Bail Act, and those charges are as follows. This bill adds Section 33A of the Crimes Act 1900, discharging a firearm with intent to cause grievous bodily harm or resist arrest, which carries a maximum penalty of 25 years imprisonment. Speaker, I ask for a shorter extension.
The member seeks an extension of time. Is the extension granted? Yes. Granted.
The second is Section 93GA of the Crimes Act 1900, firing at dwelling houses, buildings or motor vehicles. This bill will increase the maximum penalty for that offence to 16 years imprisonment and to 18 years imprisonment imprisonment where the offending occurs during a public disorder or in the course of organised criminal activity. The new aggravated offence under Section 93G1A of the Crimes Act 1900, causing danger with a firearm where a pistol or prohibited firearm is used, this offence is introduced by the bill and carries a maximum penalty of 14 years imprisonment. Section 86(3) of the Crimes Act specifically aggravated kidnapping, being a kidnapping offence committed in the company of another person or persons and occasioning actual bodily harm to the victim. This offence carries a maximum penalty of 25 years imprisonment. These additional offences are all high-risk offences that present a grave risk to community safety while preserving the appropriately confined operation of Section 40. Collectively, these amendments are another example of how this government is acting swiftly to respond to community concern and better protect the people of New South Wales. By making these changes to the Bail Act, together with the other legislative amendments in this bill, the Parliament will better ensure that New South Wales can respond effectively to serious offending and organised criminal activity. And Speaker, it is for these reasons that I commend the bill to the House.